As part of the Brexit process, following the election of Boris Johnson as Prime Minister, there was a deadlock. When I say election, the election by the Conservative Party of Boris Johnson as Prime Minister, there was a deadlock within Parliament, and to break that deadlock, there was a use of what was called prorogation, when you suspend for a short period of time the sitting of Parliament. And astonishingly, the Supreme Court, a case was brought by a woman called Gina Miller, and the arguments were put together by a man who rejoices so appropriately in the name of Lord Panic. And Lord Panic put forward an argument that the essential purpose of Parliament is to hold the government to account. Therefore, to suspend the sitting of Parliament is an affront against the basic function of Parliament. Ergo, the prorogation was illegal. And the idea that the court of law can rule against the government and Parliament exercising its own power of self-government seems to me to break the whole principle of English government since the 17th century, the whole principle of English government since the Glorious Revolution and the Bill of Rights, which declares that proceedings in Parliament are susceptible to no other court. And I was astonished that the government let it stand. I was astonished that it was ever ruled to be judicable. But this is one instance. But there have been other instances even more striking recently. You may remember the operations of the Sentencing Council, which I have no idea why the Sentencing Council exists, but what it effectively says judges, and it's a group of judges and criminologists and other academic criminologists and other such doubtful people, telling judges that although the statute says, shall we say, that the sentence ought to be 10 years, you should really give a sentence of about 4. And it then started to say, and by the way, if you are dealing with people who belong to religious or racial minorities, you should actually refer them for as it were, social reports on them, which are inevitably or invariably a next step to the reduction of the sentence. So you effectively say that anybody who is, you were talking about minorities, anybody who belongs to a religious or racial or a gender minority or something shall receive special treatment, shall receive a lower sentence. They will be referred to a probation worker, to a social worker for investigation, and invariably, of course, it will come back that there are mitigating circumstances. So you introduce two-tier sentencing. Now, what happens? Robert Jenrick, the Conservative Justice spokesman and Shadow Lord Chancellor, gets up and denounces this. The woman sitting opposite him in Parliament, Mahood, the herself clearly Muslim, nevertheless gets up and says this is completely wrong, that it is wholly wrong, that there should be this two-tier sentencing, which seems to put one's, as it were, identity politics, gender, race, religion, above an equality before the law. She says this is absolutely wrong. What is the reaction of Lord Justice Davis, who is the chairman of the committee? No. What is the reaction of the Lady Chief Justice? It's intolerable that a politician says this. This is the law that has systematically got above itself. So as we've seen, the structure that Blair created with the quangos and whatever means experts get above themselves. The structure that the legal system has done means that judges, another group of unelected experts, get above themselves.